Hey, what's up, guys? Welcome to a Rescue Michigan Tuesday night live stream. We're here with Matt Wilk. We've done an episode a couple weekends ago where we were going to cover some court cases, and then I'd almost forgotten, but then we remembered to go back because there's been a lot of updates in the legal world, and obviously, frankly, we could use some happy news because it's just one thing after another. Today we have well, first we have Trump announcing that he's going to send weapons to Ukraine. And then we have, of course, Pam Bondi coming out and saying, hey, you know what? All those documents we promised you we're going to give you. Yeah, actually, we're not going to give you anything. There is nothing. We're shutting this whole thing down. And all those promises they ran on were for nothing, I guess. Which, by the way, Matt, you sent me a whole bunch of these case documents. But then there's this mysterious note that you say, if you force me to, we can mention Epstein. So I guess you've kind of compelled me. What's your take? There's a legal angle here on this episode.
Yeah, there's a legal angle that people need to understand, and that is, so boiling this down, the basics of the case are sexual assault. Okay, sexual assault is a state crime, generally not a federal crime. This particular island was part of the Virgin Islands. They act as a state, even though they're a commonwealth. So their laws are going to apply. And there are a whole set of rules. And I'll preface this by saying it would really be nice if the highest ranking law enforcement attorney officer and the attorney, who both have legal degrees, could explain this to the American public, but they haven't. So there's a whole bunch of rules about sexual assault victims and the releasing of their names. There's also rules about releasing the names of people who have been investigated but not accused of a crime. Okay, think back to Comey and Clinton. You remember when Comey announced that they had investigated Hillary Clinton and found nothing found something and then nothing, or whatever, however it went. And there was this big hullabaloo about that violated FBI rules, because you're the FBI, you don't announce the investigation of or confirm the investigation of someone you do not charge. Okay, so let's say X and Y person, let's say Bill Clinton was on Epstein Island. I have no idea whether he was or not. Let's say he was. What would it take to charge him? Well, you'd have to have more than just a flight log or a written note in a thing. That's actually goes a long way back with Johns and prostitution and black books, the mob and all this. That goes a long way back. So you got to have more. And one of the things you probably got to have is testimony of the victim. Now, sexual assault does not carry an infinite statute of limitations. See also Donald J. Trump and Jean Carroll. Okay, where the state of New York had to change the law to go after him after the fact, which is ridiculous. So it is unlikely that any of these people are going to get charged with sexual assault unless the person who was sexually assaulted testifies. Okay, and then it's still going to be a challenge, right? Because it's many, many years ago and all those things. But it's possible. If I were running it, I would say I reach out to the victims. What do you want? And if victims say, I don't want any more part of this ever. This part of my life is behind me. I want nothing to do with it. Then you kind of have a tough thing, because without a victim, you're not going to convict anybody. And then you go back to the question of, do you release people's names who have been investigated about a crime that they ultimately were not going to be charged with? Okay. So that's not an easy call. It's always a chance. Hey, we investigated so-and-so. We found nothing, right? We didn't find enough information to charge. So they sort of tried to do it without naming the names. That's all true. Hearsay is a problem. There's all kinds of issues in this case. But I will say this. You're Pam Bondi and you say, I have the list on my desk.
I'm going to release it.
And then you say, it doesn't exist. Those things cannot both be true.
Right. Of course, just to show one example of many, here we have, hold on, let me pull it up. I seem to have a lot of tabs open for some reason. Let's see here. But I do have a video. Hold on. Here we go. Watch this for a second.
Incredibly disturbing. We have flight logs, we have information, names that will come out.
Is it going to be shocking?
I don't see how it's not shocking.
We have names. They're going to come out. It will be shocking.
It was in fact shocking. Maybe there's this, we just read it wrong. It was very shocking that they would say something and completely backpedal. Why did all these influencers walk out of the White House with a binder and not a single one of them said, hey, this doesn't really have any of the information we were looking for? And so, look, I'm not a huge conspiracy theorist. I'm not going to buy a bunch of stuff. I'm a believer in Occam's razor. The simplest solution is the correct solution. But the same hand, you can't ham-hand these things, right? If you have an opportunity as the Attorney General or as the head of the FBI to explain to the American people how our legal system is different than other countries, right? We have different rights that many countries copied from us, right? The right to confront the accused, okay? You cannot accuse someone of a crime and then have that evidence before a jury, and there's no, the person who made the accusation does not face confrontation. It's the confrontation clause to our Constitution. You just can't do it. And that's different than other countries. Other countries don't do things that way.
One might imagine with these hundreds of victims that maybe most of them even would want to just move on with their lives, but some of them might actually want justice.
Well, some of them, some of them did. Some of them actually sued. And the information involving their cases was handled in their suits. And my understanding is there's a case out of California that had, because one of the things they mentioned is a court seal. And there was a case in California where a victim did sue, and they kind of gave a lot of evidence, and the court said, no, which is common. These are accusations about people who are not defendants. There may be subject to hearsay, and we're going to seal that evidence. And I believe that lawsuit was either settled or handled successfully.
But they're not saying, oh, there might be some cases still pending. No, they just said we're shutting everything down.
That's criminal cases. This is a civil case. This is a case where a victim sued, said, hey, I got raped on your island. I found the one from the Virgin Islands. The dude had a lot of money, which is another question. Yeah. I mean, if you're the FBI, you can't figure out where this guy got $560 million from? Because when he died, that's what his trust in the Virgin Islands, which is a part of the United States, said they had.
Amazing.
Weird. That you can find, right? So that's my 2 cents. This is not my favorite issue. So, but
let's get to some happier news then. We've got a bunch of cases to talk about. Which one do you want to start with? You want to start with Medina versus Planned Parenthood?
Let's do Planned Parenthood.
All right.
Because it runs right into the news of the day about Planned Parenthood and this idiot judge in somewhere out east who, single-handedly tries to stop a law passed by Congress and signed by the president. Well, anyway, Medina is a case where the state of South Carolina said, hey, for the benefit of everybody, Medicaid is a state-run program funded by the feds. There are rules that must be followed, but the states, as a general, will make decisions, coverage levels, that kind of thing. So you've heard probably quite a bit about expansion of Medicaid and how some states did and some states didn't, because states have leeway to do that. So in this particular state, South Carolina, they said, yeah, by the way, no Medicaid payments to Planned Parenthood. Okay. And of course, Planned Parenthood goes ballistic because, well, you see, most people understand money is fungible. So while they can't fund abortions, what they can do is all this other stuff, and they can use their profit to fund abortions. So they went through and
let's elaborate on that for the benefit of the people that might not quite follow that. When you say money is fungible, what you mean is the federal government's writing you a check. Like, let's say the government writes me a check for my grocery bills. That means I have more money to spend on my car.
Correct.
So because of that, when you say no funding for Planned Parenthood for Medicaid, because Planned Parenthood, of course, their main industry is killing babies, but they also claim to offer birth control services and things like women's health stuff to cover for the baby killing. So if the federal government says we're not going to give you any money because you're going to spend it to kill babies, they're going to come back and say, well, no, we'll just use it for women's health programs. Like, well, yeah, but that's because that by funding the women's health programs, we indirectly are basically subsidizing your baby killings.
Correct. And the question isn't whether the state had the right to do that under like the Constitution. The question was, when the state does that, and particularly when the federal government doesn't object, does the provider have some sort of constitutional right or statutory right to go fight? And the answer to the question, the court said, was no. And this was a great 6-3 opinion. Neil Gorsuch wrote this one. And it says, hey, look, if they want to cut out Medicaid, the statute cut out Planned Parenthood from Medicaid, the person responsible for managing that question and whether that question violates the law is the person who funds Medicaid, and that's the federal government, right? It says specifically that if they fail to meet any condition, the secretary of HHS may withhold some or all of the state's federal funding until he is satisfied there will no longer be any such failure to comply. And of course, because of the world that we're in, the Planned Parenthood this time, well, no, we're going to sue individually. We have the individual right to be used under Medicaid, which is completely ridiculous, right? And their contention was, well, anyone who meets the criteria must be funded. State disagreed, voters disagreed, the feds disagreed, which is very important, and the United States Supreme Court said, nah, we're with them. There's no private right of action, is what it's called. You have no right to sue to get this changed.
So it sounds like this actually could even go beyond just simply defunding Planned Parenthood as a separation of powers issue.
Right. And so basically, if a state decided, I'm not funding blank, right? And a lot of these cases are intertwined. What happens in the Supreme Court is that they argue their term runs from October, and then this year was unique because the CASA case was in May, but most of the time by April, they're done. And then along the way, if the cases are easy or they're 9-0s or they're pretty simple, they get resolved relatively quickly. But at the end, you'll find that a lot of these things are sort of tied together. And this particular one was tied to this concept of, does a person, an individual or a business, basically have the right to go in and challenge this sort of statutory interpretation, which is consistent with what they've said before. But in this case, they said it's not that the statutory interpretation was wrong. It's that there's only one way. The statute makes one way to create damages, and that's you can go to the feds, and the feds can withhold your funding. Well, in this case, the feds said, no, we're not going to withhold the funding under Trump. And so win one for the good guys here.
Yeah, let's hope there's more rescission of federal funding for a number of things. Although Congress has 10 days left to pass some of these DOGE rescissions, so we'll see if that ever happens.
Well, they're going to do this cyclically, though. They're going to do this on a ongoing, repeated basis. They still have appropriations to do. That's going to be ugly and nasty.
Yeah,
if they can still get along, I mean, the process of appropriations has got laden with garbage. Everybody knows it, and it'd be interesting to see. Yep.
All right, should we move on to the next case?
Yeah, what do I have for next?
All right, next one looks like free speech versus Paxton.
Oh yeah, okay. So
in here, so it's more
free speech versus Paxton was a case, which is also a 6-3 ruling. I think it's a little surprising. Might be a little surprising to sort of the libertarian bent of our party. One of the problems that we run into is often the border of freedom and then sort of things involving kids, right? And that'll be a theme this year, and that's the theme in the coming year.
Is this a lawsuit against the the ID for pornography law in Texas?
Correct.
Oh,
very
yeah.
good. You're very good. You're up on top of this stuff. So
Well,
basically,
I can also just read it right here. In 2023, Texas passed this law requiring ID to view pornography. So
right, and I think there were several states, 15 states, something like that, that passed this law. And what they said was, you have to prove that the person who's looking at it on their phone is over the age of 18. And by the way you were going to do that is, I think the services were going to, I think I read that you got to upload your ID or something. Yeah. To which the Free Speech Coalition sued and said, hey, that's
a very funny name they have there, the Free Speech Coalition.
Well,
it's not called Cum Dumpster Inc. That's not the name of the plaintiff in this case. I wonder what that would be.
The precedent-setting case originally for pornography, effectively as it were, to be free speech was actually here in town. It was in Detroit, and Detroit had, at the time, if you can think how crazy that is now, effectively banned strip clubs, and you couldn't be 1,000 feet from a church or a school, and at the time, basically, it was the entire city of Detroit. And Coleman Young was the defendant in the 1970s. And the Supreme Court said, no, pole dancing is a form of free speech and protected. And they've always struggled with this all the way through, right? If you remember Edwin Meese, and they stood there and they said, former Attorney General, they said, got to try to get him to define pornography. And he said, I can't define pornography, but I know when I see it.
Yeah.
Right. And he was standing in front of a bust of I don't know what, and it's a half-naked woman.
Yeah.
And that's, it's an interesting conversation. But anyway, in this particular case, it was whether the process of requiring the ID to be uploaded, the question wasn't, does this burden free speech? Because the justices agreed that it did. When you burden a fundamental right, there's three levels of review. Okay. There's
strict scrutiny.
Rational basis is the easiest. You have any rational basis for this law.
Right.
Almost always, rational basis is those laws are found to be constitutional. Way at the other end of the spectrum, strict scrutiny. Is there you're burdening this right? You have to basically prove there's no other way you can get done what you need to get done without burdening this right. And then the middle is intermediate scrutiny. There's a right here, but there's an important interest here, and is it sort of narrowly tailored, and does it meet the criteria? And the court found that yes, this was a burden, but no, it survived the intermediate scrutiny review that it should have. And what makes the case interesting to me is that they took Texas, they wanted to do the Fifth Circuit, and I'm not sure why they chose that versus, say, the Fourth or something, and maybe get a little better appellate review than the one they got. So I'm not because the Fifth Circuit in this particular case said no, that's the lower court, and people need to understand there are 12 circuits in the United States, and they're based on geographic. Texas is in the fifth. The Fifth is a relatively conservative court. It probably is the most conservative court we had, with the Ninth and maybe the DC Circuit and 1 or 2 being the far left. And they went there, and the Fifth Circuit said, no, this is protected. And the Supreme Court, not protect this particular provision is okay. And the Supreme Court said, we agree. Not sure why they did it, why they made that choice they did, but it's an interesting case because there's always a border of what people's rights are versus, especially things involving minors. And you'll see that's going to be repeated once and then in a preview. So you'll see that concept again.
Yeah, if you've got parts of this decision you want me to flip to, let me
know. This one isn't the ones I wanted. This one's a drive-by shooting here.
Yeah,
because this one's pretty. I think people understand this one pretty easily. There's a couple other ones that I want to dig into a little more.
Sure. By the way, folks in the chat, if you've got questions for Matt, feel free to ask them. Should we move on to the next case then?
Let's do that.
All right. The next one it looks like I've got is U.S. versus Skirmetti.
Scrimetti is a great case.
All
Okay,
right.
Scrimetti is a great and a longer case.
This
Um,
is well, you guys can see on the screen here.
Okay, so Scrimetti is the case that predated Mahmoud, and it's going to be a precedent-setting case because it triggers what happens in the Supreme Court is they do this in steps. Okay, and the steps are they don't just jump to the overruling or seriously limiting of a precedent unless they have to. But what they do is they approach it incrementally. So sometimes it frustrates us because we win elections, we appoint judges, we expect Supreme Court cases to be overturned and promptly, and it just doesn't work that way. So this particular case is an example of one that I think is going to be it sets things on a path to provide some very interesting changes in the law that's been presented. So this particular case has to do with Tennessee State Bill 1. And Tennessee State Bill 1 said, no, you cannot do basically sex changes, hormonal things, any of those things to minors.
No permanent sexual mutilation of minors.
Period.
Yep.
It doesn't matter whether the parents think so or not. Okay?
Yeah.
You cannot do that. And you cannot do that if the purpose is to treat gender dysphoria, gender identity disorder, or gender incongruence. So if you are a young lady and you have a hormonal problem with your lady hormones, could you get lady hormone therapy? And the answer is yes. Under that law, you could. Okay. But you couldn't use it to go the other way. You couldn't give a boy female gender hormones because that boy thought they were a girl. That boy had gender dysphoria. And this is one where, so the court ultimately ruled, hey, no, this is not treatment on the basis of sex. Even though the same drug could be used for one sex, but not for the other, they were able to say, well, that's really related to the condition that you have, say, lacking testosterone. Okay,
Right.
so you take testosterone as a young male because you're lacking it, and that's okay. Now, one of the things and the facts of it are interesting, but it's what some of the response is that the court rejects. Number one, the court rejects the concept of this decision being subject to what we just talked about, some sort of strict scrutiny or even intermediate scrutiny.
Yeah. They
say, no, it's not. And I want you to go, I don't know if you have that PDF open. Let's go to
I've got this tab here too.
Yeah, go to page 19 of the opinion.
Okay.
Please, and there'll be a 19 in the upper right hand corner.
Here we are.
Okay, go to the second, yes, right there where it starts with we have.
We have not yet considered whether Bostock's reasoning reaches beyond the Title VII context, and we do not need to do so here.
Oh, and then that is very important. That is hugely important. Because what John Roberts says is, wait a minute. You guys across the country have been interpreting Bostock. Bostock was a case where a transgender man with gender dysphoria worked. I hate the term transgender. I will use the term man with gender dysphoria. The man with gender dysphoria worked in a funeral home. And the funeral home fired him because of his gender dysphoria. And they said, you can't do that. Okay. Now, the question was, did that put gender dysphoria as the same category as race, sex, religion, et cetera, et cetera, et cetera? And the left screamed for years, yes, it did. And here's John Roberts saying, did it? Did it? Because no, it didn't. We limited Bostock. We have not yet considered whether Bostock's reasoning reaches beyond Title VII, which is employment context. Okay? Very, very clear. So if you are trying to assert a constitutional right based on your gender identity, and we'll talk about it in a second, you got a problem. Because the Supreme Court has identified to you, and if I'm the attorney for their side, I say, the court here is really clear. They've never expanded this. This is not something that's well established under law. This is something that's, that's not yet decided at best. So that's a massive, massive change. They then subject the law to rational basis review, and they say, yep, this particular state has a rational basis. Could you now go, so that's one really, really important point. The other really, really important point is on page 24, if you want to go to that.
Sure. By the way, I find I can barely even follow this because when it says here, if a transgender boy seeks testosterone to treat his gender dysphoria, I think they're actually talking about a female. And you can't
Correct. And it's funny because if you scroll up, they put it in a footnote, and they got a little bit of grief from people saying, why did you accept the language? I have asked everybody, it's too confusing to me. It is boy with gender dysphoria, girl with gender dysphoria. And I think it clarifies the issues around that, right?
Yeah.
Can a boy with gender dysphoria play girls' sports? Sounds a lot different. Okay.
Yeah.
So go to
chicks with dicks, you call them.
That's one way. So page 24, which is the end of the opinion of the court. This is the opinion that's signed by everybody. Go to the last paragraph, please, of the opinion.
Yeah, here we go. This case carries with it the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. The voices in these debates raise sincere concerns. The implications for all are profound. The Equal Protection Clause does not resolve these disagreements, nor does it afford us license to decide them as we see best, which is what essentially what the theoretical transgender activists were hoping for, is that they can hide behind civil rights laws as their way of forcing their bizarre medical theories on the public.
Right. And they can get an expert to come in and say, this is important, whatever. And they can win that argument in front of a single judge instead of in front of a state legislature with a law that's got to be signed by the legislature and signed by its governor, which they lost handily, and in a lot of places has lost as well. So they know they're going to lose that overall argument. So then this is the court again signaling, and there's some discussion in it a little later, signaling, hey, this is you just can't throw out a bunch of experts and say we're going to override this law. That's not a method that you can use to this. So that's the suggestion. And now go please to page 5. Justice Thomas, in his way, he's, and I miss Justice Scalia, but one of the things his death did was Justice Thomas came out of his shell.
Yeah.
And he is now asserting himself in his brilliant mind and his brilliant answers. And so go to page 5 of his concurrence.
Okay.
And it's 5 sub. It starts with number 2.
Yep.
And what he does, starting here, he says the court rightly rejects efforts by the United States and the private plans to accord outside credit to claims about medical consensus and expertise. And the left was just out of their minds about this. The experts say, so we remember it all, right? We remember it. You and I remember it.
Yeah.
What do the experts say about
science?
What's the science? What do the experts say about climate change? What do the experts say about COVID, masks? I had somebody at a school board meeting say that to me. She said, she poshed the whole crowd. There were 70 of us in the crowd. And she said, it's the science. And the science she was referring to was making kids under the age of 4 wear masks. So no, madam, it wasn't in fact the science. It was wrong. And what he says here, he breaks down
Oh, yeah, here we go.
exactly
There are
why.
several problems with appealing and deferring to the authority of the expert class. First, so-called experts have no license to countermand the wisdom, fairness, or logic of legislative choices, i.e. we the people.
We the people.
Second, contrary to the representation of the United States and the private plaintiffs, there is no medical consensus on how best to treat gender dysphoria in children. Nice. Third, notwithstanding the alleged experts' view that young children can provide informed consent to irreversible sex transition treatments, whether such consent is possible is a question of medical ethics that states must decide for themselves.
And I hope you got the dagger there.
Yeah. Oh, yeah.
Alleged.
Yeah.
Alleged experts. Okay.
And fourth, there are particularly good reasons to question the expert class here, as recent revelations suggest that leading voices in this area have relied on questionable evidence and have allowed ideology to influence their medical guidance. Nice.
So it's a warning to all these cases across the country. If you walk in and your case is based on this is the science, this is the best way, I earn a constitutional right to do something because this is what my experts tell me, the court's thrown that out. The court has chucked that. The only other part about this case that was interesting is so the majority said this case really isn't about sex, and they aren't done beating this horse. So can you go to it's page 53 of the PDF? It's the first part of Justice Barrett's opinion.
I will do that, Matt. But I tell you what, here's where it is. However, I'm having an issue with Facebook right now. They apparently our stream just kind of stopped all of a sudden. So I have to go onto our Facebook page and post a note saying the stream ended for no reason prematurely, but please visit our YouTube or whatever.
Okay.
Yeah, we got kicked off of Facebook. I think accidentally. I don't think it was for any kind of chicks with dicks censorship reason or anything like that. But apparently we are no longer airing on Facebook.
Okay, you are on Twitter. I was able to. I see 20 plus people watching on Twitter, so that's good.
Yep.
Okay,
so go ahead and continue. I'm
okay,
sorry,
so
type this out.
In this particular case, they make it even clearer. Barrett, who a lot of people thought was a squish, particularly on this issue. I write, the court concludes that the bill does not classify on the basis of this transgender status, but we avoided the issue of whether transgender status is a suspect class at all. And I say it isn't. And Thomas agrees. So a further undercutting of this concept by walking into a room and declaring that you have gender dysphoria, right? That you have established some new constitutional right in your benefit. Now, where does this carry over to? Pronouns. You must use my pronoun. If you're not a suspect class, which you're not, you don't have any right to tell people what to say. You might not, even if you are, right?
Yeah.
But you're certainly not that anymore. If you're not a suspect class, is the underpinning of that Bostock case really not that good? If you're not a suspect class, all these other things that come along with it all fall away. And Title IX is a big part of that too.
Right.
Okay, so that the last part was after Barrett lays that hammer. Alito says, "Yeah, you know what? It was on the basis of sex, but it doesn't matter because it's not protected anyway." You know, crusty old Alito was great.
Yeah.
It was great too. But I think we've beaten that one pretty good. If you want to move on, we certainly can.
Sure. And again, feel free, folks in the chat, if you've got questions, we'll stop and address those. Okay, the next one we've got here, let me make this bigger, is Ames versus Ohio Department of Youth Services.
Okay, so this is a rare bird. Okay, now in the Supreme Court, what happens is they take a case and they get it in, and they do sort of an informal straw poll. And they say is, where does everyone sit on this issue? And the Chief Justice, if they're writing in the majority, they designate the author of the particular case. Okay. And these are generally spread out because the work to write an opinion is very hard. So what you kind of try to do is you try to throw people a bone. Okay. This particular case, for people that don't know, if you file suit and claim that you are you've been racially discriminated against or one of these things in the area of employment, you have a heightened standard in the Sixth Circuit. This is Ohio, where we live. That you have a heightened standard if you're if you're not a member of a protected class. So I'm getting a little older, so I'm getting close to that older, but white male. So it'd be more difficult for me to do so. And this is Title VII. It's federal. And this particular woman, she's heterosexual. And she worked for the Ohio Department of Youth Services. And she wanted a promotion, and she thought she was entitled to one. And they didn't hire her. And they hired a lesbian instead. And all the other people above them were gay as well. Now, let's pause for a second and say, why does the Department of Youth Services have nothing other than gays working for it?
Huh, I wonder why.
That's a really good question. It seems like you might not be, I don't know, doing youth services things. And what's interesting in this case is not necessarily the opinion. And the opinion was that no, the background circumstances rule, the higher standard for non-minorities, is a violation of the Constitution. That's pretty groundbreaking, right? So for cases where, because in the United States we allow for disparate impact cases, right, where you say, hey, we represent X percentage of the population and we represent Y percentage, some smaller percentage of something beneficial, we can make a prima facie case to go to court. Well, that math works out really tough. So if you live in a primarily minority community, you live in the city of Detroit, and you make up 13% of the population and you make up 2% of the management of the police force, it's now easier for you to make a claim in that regard. But here's what's funny about this case. Scroll down and see who wrote the opinion. Held, blah, 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 blah. This is what we said. Whoa. Who? Wait, what?
Not a biologist.
She's not a biologist. And you want to take it a little bit easy on her. Why? She's had a really rough couple of weeks. It's really rough to have your colleagues sign on to a 6-3 opinion that comes as close as possible to saying you're an idiot than it did. Yeah. Where they say your dissent this was in the CASA case, your dissent has nothing to do with law, and it's all made up stuff. And her bad week continued all the way through today, as a matter of fact. So that's what made that one interesting. I think that's something that conservatives can cheer about. It was clearly a 9-0 case. It was so bad, it was given to Jackson. In your opinion, say no, there isn't a higher standard for people who are a non-minority to prosecute or pursue rather this kind of case.
Amazing. 9-0.
9-0. And one of the things people kind of think every Supreme Court case is ideologically driven. It's not. There's very, very weird shifts that happen from time to time. Some of them are pretty consistent. There were a bunch of 6-3s that we were talking about last week, and we'll continue on this week. But sometimes the 6-3s become 7-2s and 8-1s. Yeah. Right. Because the cases are not they're worse than they were put together.
All right.
What you got?
To move on. All right. Next we have Montana versus Planned Parenthood. Another bad one for Planned Parenthood.
Yeah. Well, actually, this one the court ruled otherwise. And the only reason I'm putting it out here is so people can understand. Sometimes you hear the court ruled X. You always have to read it. Adam, I don't know where you were. I know where I was when the Bush v. Gore decision came out in the year 2000.
Oh, yeah.
Okay. I was sitting in my condo in Chicago We were watching it live, and I'm an attorney. And I know when the Supreme Court issues rulings, this is 2000, so these were not PDFs that you could search. Okay?
Right.
They hand them out physically.
Oh boy.
And what they did was they handed it out to these people who immediately rushed in front of the camera to say what it said. Except for there's no Cliff Notes version, guys. And I think I watched it on all like 3 stations. I'll flip it back and forth. And these guys they're flipping like they don't know where the answer is. Where's the answer? And they had to look to like the end of I think even the end of the main opinion just said it is so ordered. Like you got to read it yourself, right? And it was hard, right? So a lot of times people hear a result of the case or a decision and they need to know sort of why. So in this particular case, this was the state of Montana had required minors to seek their parents' consent for an abortion. Okay.
Yeah.
And the state of the plaintiff, often in Supreme Court cases, the plaintiff and the defendant reverse their way up the court. So just because this one's called Montana versus Planned Parenthood, originally the case would have been Planned Parenthood versus Montana, and they flipped for a procedural reason. So in this particular case, Planned Parenthood filed a lawsuit saying that this particular law violated the Montana Constitution, not the U.S. Constitution,
right?
The Montana Constitution. And it got all the way up to the Supreme Court because the next step after a state Supreme Court is the United States Supreme Court. So you go district, circuit, Supreme Court. If you're in federal court, you go in Michigan, circuit, appeal, Supreme Court, U.S. Supreme Court if you're in state. I don't know how many courts they have. So people reading this case, when they saw the press releases on this, court rules, blah, 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 completely wrong. Scroll down a little bit and you'll see the end of this is a statement that Alito and Thomas made about the case. And this is really slapping down the people in Montana. And because what you file what's called a petition for certiorari. All right. And the petition says, Your Honor, this is what I want you to decide. This is my issue. And often in these cases, one person will say this and one person will say they'll frame the issue differently. And the court picks one. And often when they pick the one, you kind of get a sense of who they think's the winner. In this case, they took it all the way up through the Montana court, but they never addressed the issue of whether you had violated parental rights. They never addressed it. And then they went to the Supreme Court and said, well, we'd like you to address whether this impacts parental rights. And Alito, who would love to address the issue of parental rights, says,
You can't ask us this because it was not asked of the Supreme Court.
Because of the way this case was litigated below, it provides a poor vehicle for deciding that question. Yeah. It is therefore essentially important that the denial or review is not read by interested parties or other courts of a rejection of the argument the petition asks us to decide. So a lot of time cases are done on standing or jurisdiction or timing. This one was like, guys, you didn't even argue this properly. So we're not going to address the issue. We're going to deny it, but they've left the door open, right? People need to know that the standard of review for a particular case is 4 justices. So if 4 justices vote to accept cert, they'll do it. And a lot of times there's something called the courtesy fourth, where if 3 justices want it, a 4th chimes in to bring it up, even if they know they're going to get kicked in 6-3. So it's either 3 or 4. Well, you've already got 2 who said, I want to know if parents retain this is a parental right. And so somewhere across the country, someone's going to make this argument and they're going to bring it and it's going to go to the Supreme Court.
Good. All right. So next we have a case that is extremely fresh. In fact, this came up today. We have Donald J. Trump versus the American Federation of Government Employees Union.
Yes, correct.
All right.
So, and you can only decide it's happening all the time, and I just don't get it. Okay, I don't get why these, and this sort of predates the CASA ruling. CASA was the one we talked about last week that talked about universal injunctions, and the court made it very clear that you can cover your plaintiffs only. Now, in this particular case, they didn't really have that as an issue. AFSCME is the plaintiff in this case, again, with the flip-flopping, right? So AFSCME sued the Trump administration saying, your plan to reduce force, the government workforce, is a violation. And this is fresh. This is today. And it highlights something that people need to know exists, called the emergency docket. Okay. Mm-hmm. One of the reasons why CASA was so important is prior to CASA, the United States court docket was filled with these emergency applications for the Supreme Court. Previously, there would be some, mostly in and around the death penalty. The death penalty is always considered an emergency docket application.
Yeah.
But they get sick of it. They really do. They don't like being put on tight time frames. They do not like it. And in this particular case, this district court said, nope, the president's executive order is withheld. He can't do that. Now, one of the things in that case was, in the CASA case, was judge shopping, which clearly happened here.
Right.
And they want to stop it to file it back, right? In a case where you are fired from the federal government, you have one and only one right, and that is to seek arbitration. To resolve your employment matter, right? The United States government has not waived sovereign immunity. That is the right to sue the sovereign, the right to sue the government, unless you complete that. Okay. So in this particular case, the court goes through and says, in particular, hey, because the government is likely to succeed on its argument that the executive order and memorandum are lawful, we grant the application. Okay. The government is likely to succeed. Okay. Where it gets interesting is Sotomayor, which is on page 2, says, hey, everybody, and I wonder who the everybody is she's talking to. This executive order here says they have to comply with law. So you probably have to wait for them to break a law to come to us. Yeah, probably. Mm-hmm. Which is a very polite, a very good response, a very polite response, because it's not directed at the 7 other justices that signed off on the first matter. It's directed at her friend who writes below as if no one else is in the room talking. Right? So she says, I agree with you, but then Justice Jackson, who's continuing her very, very bad week, writes a dissent where she says and normally the Supreme Court is pretty tolerant of kind of the back and forth that goes on. They respect each other's intellectual abilities, but there are exceptions. And I think this is another one where she writes, if you want to scroll down a little bit, you just see the idiocy of it. So Justice Jackson says, excuse me. Oh, no. There's no congressional buy-in to this executive order. Right. What? Is there often? Is there ever? Who runs the executive branch?
Yeah, really.
Right. I mean, and she flails around, and there are facts, and this, and that, and that, and that, ignoring the entire procedure, the posture of the case, and then goes after the people who are writing the opinion, which is all 7 of them, saying, well, I don't understand. If you look at It's her.
How could this court possibly know if it's likely to succeed in the merits? Who ever heard of a court deciding before a case whether it's not it's likely to succeed in the merits? Never happened before.
It's idiot. Now go down the first line of paragraph of page 2, please, just to scroll on a little bit.
Sure.
And she says, where? I'm sorry. I want to be on full page 2 of her dissent. I'm sorry. You need to go to her dissent. Did I send that to you?
This is it.
Okay, hold on. Where we say, yes, right there, where she says, the temporary practical harm reducing preservation of the status quo was no match for this court's demonstrated enthusiasm for greenlighting this president's legally dubious actions in an emergency posture. Okay, lady, let me explain. Number one, the court found above that they are likely to win on the merits of the case. So it isn't legally dubious when somewhere between 7 and 8 justices think it's not. But when you take it further and try to say these people are somehow puppets of Donald Trump, that doesn't lead in the future to your ability to sway justices to your side, which is how the Supreme Court works. You walk in, and there's 9 very smart people, and they all make their cases, and they move each other around a little bit on these opinions. And sometimes it leads to bad results, right? Sometimes it leads to things where you say, well, we're only going to touch on this topic of an issue when we want more. But for the life of me, I do not understand why you would throw barbs at these people after the friggin' week you've had, where you have
Amazing
Amy Coney Barrett just basically ripping your face off and talking about how poorly your work was done. And, you know, they don't write the opinions themselves. They have court clerks.
Mm-hmm.
I have no idea if the court clerks are in the same intellectual capacity as the justice they work for. And they may not be the best, and they might be writing dumb opinions and getting them thrown out. I just don't know. But that's a good result. It's an expected result. And I think the court is going to relatively quickly clear their emergency docket by saying we're not tolerating any of this stuff. And that is going to take out a very common strategy that the left had that they were using, which is if they lose in the legislature and they lose in the presidency, they're just going to go to court, they're going to find a judge, and they're going to block it, and they're going to run off the clock. That's not going to happen anymore.
Good. Right on, man. Well, hey, another question for you, because we talked about this on the show the other night. There has been this case where Trump has filed suit against all of the judges on the federal bench in the District of Maryland, and because of that, also therefore demanded they recuse themselves from the case and have another court hear this case. You know,
I haven't really followed that, but I want to make. There's one thing that people need to know, and our good friend Patty P and I were talking about this and a little earlier, and I said, you know, it's really hard to get rid of a judge. Okay, the grounds for removal of a judge have never been effectuated on the purposes of bad decisions. They haven't been effectuated on purposes of when you find clear and obvious stupidity. Okay, we had cases. I had a case one time where the appellate court disposed of a circuit court matter in Michigan in probably about 20 minutes because it was so poorly done. It was a summary reversal. Just get out of here. And there's nothing now in the state of Michigan. All those parties are elected, so those people don't technically report to each other, right? So here's finally, and this isn't Trump. This is the United States of America. The United States of America, our government is saying, hey, look, guys, we're sick of this. We think you judges are violating the law because you keep stepping out over what you are allowed to do. Zenas and
yeah, look at this caption. All of the judges in the federal district court in Maryland,
right,
and
look and they keep doing it. right? And you had the judge in this particular case, with the case that led to this was, I think, Abrego Garcia. And Abrego Garcia said the court ruled no injunction. I'm sorry, we're staying your ruling, staying your order, unenforceable court. A state order is not enforceable. And the judge, having received that order from the United States Supreme Court, 2 levels up from him, had a second order, which was a show cause hearing on this first order, and he said, no, we're going to move forward with this anyway, which required the Supreme Court to issue something that I can't say I've ever seen.
If you have a link, send it to me, and I'll
it's I'll put it in the chat real quick. It's they asked the Supreme Court to clarify. It says on motion for clarification.
Wow.
Motion for, when does that, like, we're normally pretty, like, we try really hard as a judge to make sure we follow what
so
the
this
court
case,
said.
by the way, I just mentioned this, since it's Department of Homeland Security versus DVD. They're shielding the name of the illegal aliens in these cases because they don't want there to be another one identified as Kilmore Armando Abrego Garcia, who they can easily research and find out is actually a gangbanging terrorist. Right. So they protect the names of them. So contemptible.
Right. They try to hide them. Correct.
Yeah.
And if you go down to about halfway down this little gem here, and it says on June 23rd, we stayed the preliminary injunction. Later that day, however, the district court issued a minute order. That's something they just do electronically, stating that the May 21 remedial order remained in full force and effect, notwithstanding our stay of the preliminary injunction. The only authority it cited was the dissent from the stay order.
Yeah.
So the government was forced to go back in and say, Your Honors, can I get you to clarify this? And the court says, the motion for clarification is granted. And they go through and just rip this guy's legal head off. You can't have a remedial order about an injunction that we rendered unenforceable. Knock it off. And
does the Supreme Court ever just sanction lower courts for being in contempt of their own decisions?
They don't have that authority.
Who does?
That would have to be a case like the one the Trump campaign or the United States filed, where you sue a judge. Now, that would probably be held in probably up through the DC circuit. I'm not sure I've ever heard of one before. This is idiotic. And this is just TDS boiling over, that this guy cannot stand the fact that Trump is passing laws. They've got legal background. They've got support that they didn't have in 2016. People need to understand this. In 2016, none of the predicate of this was done. Trump did not know how to do this. His team did not know how to do this. They're not making the same mistake twice. They are now giving perfect legal predicate to the actions they are taking domestically and saying, this is why, and this is what. And the only thing the left can do is find some judge, and they found a chief judge in Maryland. Now, what can the district court or the U.S. Supreme Court do here? They can probably direct that this case is to be held in a different court.
Here we go. So if the government wishes to seek additional relief in aid of the execution of our mandate, they may do so through a writ of mandamus.
Yes. And that you couldn't, that's like the equivalent of try that again. Why don't you try that again?
Yeah.
And it's just appalling that we keep doing this. And when you think about it, this has the strength and the power and the authority of the federal government and its infinite resources to fight these things. these same strategies are done across the country.
Yeah.
You run into one of these people and they run into a buzzsaw because they don't have infinite dollars to fight these things. And it's good to see that the court is now clarifying, getting out in front of this. But one of the things I talked about is, when you have what's Trump's play, Trump's going to do a lot of ignoring of some of this stuff, because I think it was Andrew Johnson or Jackson, one of the two. His famous quote was, Marshall has his judgment. Now let's see him enforce it.
And Andrew Jackson, I believe.
And he was, and that's not how our system is designed.
Right.
Our system is not designed for judges to make law. It's not designed for judges to enforce law. That's done by the United States government. That is an executive branch function. And if you don't like how the executive branch operates, your right is to impeach him or beat him in the next election. And they couldn't do that when they couldn't try to do the first one, and they didn't do the second one.
So I'm going to go back to this Maryland lawsuit real quick, so you can see what's going on here. So what this involves is defendants, these Maryland judges have instituted an avowedly automatic injunction against the federal government issued outside the context of any particular case or controversy by promulgating a standing order and an amended standing order that required the court clerk to automatically enter an injunction against removing or changing the legal status of any alien detained in Maryland who files a habeas petition. So the challenge orders here do precisely what the Supreme Court has forbidden, to make equitable relief a matter of right in the District of Maryland. The defendant's automatic injunction issues whether or not the alien seeks or needs emergency relief, whether or not the court has jurisdiction over the alien's claims, and no matter how frivolous the alien's claims may be. And so they're suing all of the judges in the federal circuit in Maryland. And then they file this motion for recusal to designate visiting judge and memorandum in support. So they say, because this court and its judges, all of them are named defendants in this case, each judge in the District of Maryland is required to recuse from the matter. And therefore, you have to randomly assign this to a judge in a different circuit to hear the case, because every other judge locally is now a party to this case.
And again, people that have been following, I guess we're learning a lot more about how the immigration system works. Okay.
Yeah.
The immigration courts are handled outside of what's called Article 3. Right. So if you want to come here to this country, before you establish rights, you have to go to that court and get them. Now, most of them are done legally, right? You go get a visa, you get legal permanent residence, you get a green card, whatever. But there's this whole group of people who have been given a set of instructions on how to obtain asylum. And those asylum claims are very, very difficult to sort of disprove. But the left has tried to move those into Article 3 courts where they have better judges. Because Article 1 courts is, I think, what they're called, even though I think they're legislative, even though the executive is Article 2. They do not. They're not. That standard is set by applicable law, and the interpretation of law is provided by the executive branch. And one of the things they've said is, for example, with respect to Haiti, as a recent case, we all have to flee Haiti. It's too scary. And the Fed said, we've looked at it now and it's not. You have to go home. Yep. And that's precisely what asylum law says. And what does the judge do? No. That we disagree. We disagree with that. That's not for a judge to decide. Abrego Garcia was banned in the previous order by being sent back to El Salvador. So let's send him somewhere else. Well, no. He's going to file a writ of habeas corpus. And the feds said, if you issue bail, we will deport him. If he walks out of the courtroom freely, he will be gone, and we have the right to do so. And the judge doesn't know what to do, because he wants the executive branch to do X, Y, and Z, and he doesn't have the authority to have them do X, Y, and Z. Yeah. Because it's already been told to him that the right to remove this person, that the government retains the right to remove him for any other lawful reason. And he's got a long list of lawful reasons of being thrown out of the country.
Yeah.
So
Plus, he actually lost the privilege not to go be sent back to El Salvador because that gang he was adjudicated to be a member of is now designated a terrorist organization.
yeah,
So,
exactly. And so people understand what the argument that people have made in some of these countries is, well, we're not because asylum is when you are sought after by your government. Okay. Now, the argument that a lot of these countries have made is, well, the government's really working hand in hand with the local gangs, and that's who after me, so therefore am entitled to asylum, right? But that's a matter of foreign policy, because implicit in that is you don't have control over your government. And one of the things about El Salvador, they now have a new president. Nobody can argue this guy is not trying his best to control that population, because he is. He's jailing them by the thousands.
Yep.
Right.
And enjoying the highest levels of popularity of any world leader among his own people.
Right. Exactly. So, because guess what? Law enforcement's popular. Even in rough
areas. To be terrorized by criminal gangs. Amazing.
So when you look at it from the perspective of the executive, you'd say this: well, we can't have a law on the books that says gangs are working with the government when we have foreign relations with this guy, and this guy's talking to us about how he no longer has gangs working with the government. They don't go together. And that determination is made by who? It's not made by an Article 3 judge sitting in Maryland. It's made by the federal government. Sorry, folks, this strategy is not going to work. And I'm very curious to see, this is what I'm curious to see. In the last jobs report, it showed that domestic jobs went up 345,000 and foreign jobs fell by like 800,000. It was such a big number. And I wonder whether some of the reversal of this is going to provide for the natural flow. Hey, look, man, you may have come here as on your asylum claim from Guatemala, which, by the way, you can't do that. When you file for asylum, the treaty, which was passed in the 1950s around people fleeing the Eastern Bloc, said you have to apply for asylum in the first safe country. Unless you're getting from Guatemala to the United States by boat, you've walked through several other countries. And if you're being persecuted by your government, they're ostensibly safe. You were never entitled to that. Everybody knew it. And they were all coached. They all get these NGOs will be like, here's your script. Here's what you need to say. And they repeat it, and they have no facts to back it up. So now here's the Fed saying, no, back. And I'm interested to see how much self-deportation occurs. It's going to be fascinating.
Hope there's a lot of self-deportation. Hope there's a lot of assisted deportation as well, but we'll see. Trump's kind of iffy on this.
We'll see.
We'll see. Hey, man, before I let you go, we were doing a show a couple nights ago, and Shane was talking about this Defend the Delegates thing, which I don't know if you're familiar with it, but
I am.
A lot of questions about this this whole business of the state party intervening with county parties. Can they really do that? Or I mean, I don't think they should, but I don't know.
No, there's going to be some information that'll be released out in about the next month. The short answer is no, they cannot. They are separate entities. There's a huge problem in campaign finance with control. There were some very weak connections to a series of state laws that, frankly, the people authoring that proposal do not understand. I don't know if they certainly are not attorneys, and they apparently don't have access to them because an attorney would tell them that what they're reading is wrong. I think it's a huge issue. I think we need to stop, to the extent that we can, this sort of inside the tent firing. But at the same time, I don't necessarily think that state party, I believe very strongly they do not have the authority to do so, except in one regard, which will come out in the proposal that I'll discuss later. I'll come on with you and talk about it.
All right, we'll save it for then, I guess.
And then, but yeah, that it's completely inaccurate, and we'll describe what we think works, what I think works, and we'll see what the people have to say.
All righty. Well, thank you, Matt, for all of your fantastic insights. It's really a privilege to have you on. And of course, we'll be back with a regular stream this coming Sunday at 9:00. We'll see you then. Until then, as always, guys, Matt, do you have any events, anything you want to promote, anything to promote?
If you're following I regret that I didn't mention it. So following the case, we had talked about the what they call the long conference, or the cleanup conference, and then the long conference. So the Supreme Court decided to take I think it was 3 cases involving Title IX in schools, and whether or not a boy with gender dysphoria has a right to play girls' sports under Title IX or under 14th Amendment. And they're 2 different cases, but they're the same. Those are going to be, I suspect I know the result of those. But we've also had the case called Mahmoud versus Taylor, which we talked about last week.
Yeah.
I run an organization called Get Kids Back to School. We are hosting a seminar called After Mahmoud, Parents' Next Steps, where we're going to talk about what parents need to do to effectuate their rights to opt their children out of LGBTQ content in their kids' schools. And there's a particular kind of thing we're going to go through. So parents, this is particularly targeted at parents. Parents, if you're interested, you could go to getkidsbacktoschool.org, click on the events tab, and the link is there. But we're going to provide some really good information and some great steps moving forward. It's a great time to do it. Start it over the summer. Yeah, go to the events page.
Getkidsbacktoschool.org.
Getkidsbacktoschool.org. You click on the events page. It's the one on the left, the little girl with a kid taking the book. After Mahmoud, Parents Next Step. It's a Zoom link. It's free.
Right.
Registration is required. I always ask that you register, but it's going to be a great seminar. We might have some guests from actually 2 or 3 different states, because this is so new and so fresh, and we're all on the same page. We all want the same result, which is the United States government or the Supreme Court has identified a fundamental right of parents, which is, we all thought was in place forever, but the left did not. And now it's been ratified and clarified. And now what do parents do?
Excellent. Well, there you go. Time for the webinar at getkidsbacktoschool.org.
Yep. July 16th, 8 p.m.
Excellent. All right. That'll do it for us for tonight. Tune in Sunday at 9 for a regular Sunday night live stream. Until then, thanks for all you guys do for liberty. And until next time, peace.